Good morning, sir. You're Alfredo Gayton. And Mr. Gayton was previously in court in cause number 25 DCCR 0184. Entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections?
No, don't worry.
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge, I've given the court and the prosecutor a letter report from Frank Maida.
And I've received that and reviewed it as well.
And Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, pretty honest in his PSI. He talks about drinking at the age of 11 and 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successable. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. It looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that prior to the criminal history that cannot be ignored. Obviously, of course, we'll defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
Yeah. And again, I think most of his criminal history is just drinking, and so many people have got the opportunity and it's worked for him, and he, not from anybody's fault, he's never got that help, It's okay. Is there anything you want to tell the court?
They sent me to prison and made me work. They never teach me as drinking. I always look for things. I'm always maintenance as to trustee. And I'm working on the freeways with Texas Department of Transportation, cleaning the roads, do anything. And disasters never give me a chance to stop.
But if you've gone to prison 3 prior times.
Yes, ma'am.
For DWIs. 3 times you've gone to prison. So this is your 4th felony DWI.
Yes, ma'am.
This is at some point when you get out of prison, do you say, I need help and I'm going to get help for myself instead of saying somebody else didn't help me?
I never had a chance. I have to look for work and.
But I know, but you have people like
Yes.
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
Well, finally this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Sudi, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discussed, and we willing to give an opportunity. I've been working for them for years now.
Just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing and he was not drinking. I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame. This wasn't the, I'm not saying this is the only time, but he had started drinking again. And I don't take it that he was blaming anybody for not giving help. He just said he's never had that opportunity. And, you know, when you're an alcoholic or a drug user or addicted to anything, it's easy for, you know, to say, it's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn.
But
Stop drinking. And it's hard, yeah.
I don't disagree that it's hard. But I also, if you'd never been to prison before.
Right.
And if you hadn't had the wake-up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go do it again. Your blood alcohol was 0.257. You ran off the road. You could have, I mean, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is, has killed someone or hurt someone, and the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County, you know, if you were given an opportunity. At some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I think
it's odd to me that there has not been a probation.
I think some of these he's set in jail and wasn't able to bond out, and it's one of those deals, you know, we'll plead you to 2 years or 4. I don't remember the numbers, but and so.
I mean, you got 12 years back in 2004. 12 years for your DWI. Second felony DWI. Then you got another one after that, and for some reason Bexar County said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior. Anything else?
I mean, the same thing. I just see people that, I mean, it's, you know, I concentrate solely on the fact that his criminal history is alcohol, and there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI, and they violate the terms of probation by drinking, and they come back before, I mean, all these courts, and several times we say, hey, let's give you safety, you know. And I can make the same argument. You know, you just went to court. You know, I mean, I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. But I understand the court's position.
Can I say something?
Yeah, sure.
I've been sober since that.
I'm sorry?
I've been sober since the accident. I moved to Samoa.
You've been sober since the accident?
I moved to a chair that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and he's given me a great opportunity. I know it's the chance of my life.
I can't slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about it. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if we willing to go, and I said yes, sir. And we spent 3 days, and he's a great person. He's been helping me a lot.
So here's the thing. If I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a vehicle.
No,
I mean, it would be part of your probation. So you're going to have to,
I haven't get a car.
Listen to her.
I mean, it would be a condition of your probation that you never drive the entire time that you're on my probation. You understand that?
Yes, ma'am.
Judge, if it would help the court, I'd be happy to, try to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way.
Yes.
And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10, and I lose that opportunity that I have today to give up to 14
Well, you could
years.
possibly, one thing we could possibly do is sentence him to 10 over 10, give him 180 days up front and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like a,
I don't know that it really extends the time. It just gives them time,
Right.
potentially.
yeah.
Okay, here's what I'm gonna do, Mr. Gayton. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation. There will not be plea agreements on a motion to revoke your probation. If you violate and I find that you violated, that's it. You're done. Do you understand? So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years.
Yes, ma'am.
I'm going to order as a condition of your probation that you enter and successfully complete the SafeP program, and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program.
Yes, ma'am.
You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after SafeP and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple. It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to SafeP. Anything else, condition-wise, that anybody can think of? I'm sorry? I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Gayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it, because again, this is the only opportunity you're going to get here in this court.
And thank you,
Would you
everything.
have any ability to pretty tightly monitor his no driving? I mean, I know that's just...
I don't know how to, because if I put, a GPS won't do it, because if he's in somebody else's vehicle. I mean, I'm inclined to reach out to,
Maybe some of those people who have reached out for him.
so I'm inclined to reach out to Mr. Maida and explain to him
I will explain to
about the
him.
no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first
Right.
place that ended up, I think, part of this wreck.
Right.
But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone or you're on a bike or whatever else, or walking. And that is the most serious part of what I want and need to do to make sure that the community is safe. Do you understand?
Yes, ma'am.
Okay. I don't see the certification. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived the right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, Mr. Gayton. I hope you take advantage of this.
I will.
Don't make me regret it, please. Okay.
Thank you.
A long-lasting full moon.
Good morning, you're Charles Guidry, and Mr. Guidry is charged with theft of property in cause number 23-41646. And Ms. Norman, where are y'all on this?
So, Judge, we have all the discovery, we have an offer. There's some restitution involved and some other minor things that I'd like to be able to talk to Mr. Coleman about to try to see if we can resolve this without me placing it on the trial docket.
Okay.
But I'm certain it's gonna be a plea, so if we could just reset it for a plea, and that'll give me time to talk to Mr. Coleman.
Sure. And it looks like you were just...
Mr. Smith, but
Yeah, maybe he'll work on that with you this morning. Whoever thought somebody would say that about you, Mr. Smith? Just kidding.
we go way back.
All right, so, and it looks like you were just hired in August, so we'll just do a normal reset to give you time to talk to Mr. Coleman and see if y'all can get that worked out. Mr. Guidry, stay in touch with Ms. Norman. Once she gets all that information, you guys can go over and see what the outcome will be, and we'll get it taken care of at the next court date. All right, you're free to go. Thank you. Let me find you on here again.
She's on the last page.
Okay. Did you just say the last page?
Maybe it's page 5. What's the?
I'm looking at, sorry. Okay, here we go. Ms. Hawkins on Devin Spites. Good morning, you're Devin Spites. And in cause number 25, DCCR 0023, Mr. Spites is charged with theft of property, and what is the announcement?
Judge, we had one last outstanding piece of discovery I just received this morning,
Okay,
so we can have some time to review it.
all
Be
right,
sure to visit, I think there was just a miscommunication on that thumb drive, so we gave her a copy this morning.
Okay.
While she was already here, since she made the drive, and we'll be sure to talk about it before next Saturday.
okay. So, Mr. Spites, make sure you stay in touch with your attorney so that before that next court date, y'all can go over all of the evidence that she's received in discovery, and we need to get an announcement at that next court date.
Yes.
All right? All right, you're free to go. Thank you.
Thank you, Judge.
I just sent you Judge.
All right, thank you, Mr. Coleman. Anna DC Sanchez Diaz.
Say that simple.
It's okay. Okay, well, so this is gonna be to a lesser, okay, I'll make that notation on it as well. And it's transportation code, what's the code do you know the section by chance?
Charlie and I talked about it.
Do y'all have it written down?
I don't have it copied.
Fleeing?
545.421.
545.421C. I got it. Okay. All right, are you Kevin Sanchez Diaz?
Yes, Your Honor.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Sanchez Diaz, the state has elected to proceed on the lesser included offense. And what level is that?
B, I believe.
Is it a B?
It's a B, Judge. It's my understanding.
Okay. The state's elected to proceed on the lesser included offense of a Class B misdemeanor of fleeing a police officer under Transportation Code 545.421C, and that's from March 5th of 2025. And how do you plead to that charge?
Yes, Your Honor.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a, and I said fleeing, but it's eluding, actually.
In the EPS code, it's
Fleeing.
Both, Judge. It's
Both.
leading or leading.
Okay, okay. So it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tender's number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Diaz is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the Jefferson County Jail for up to 6 months. Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. The lady that's sitting at that desk right there is with probation, and she's going to call you up when she's ready to go over your paperwork. All right? Good luck to you, sir. Thank you. Good morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again for punishment purposes. That would make this a second-degree felony offense, if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so.
Yes, ma'am.
Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay?
Thank you.
All right. Yes, sir. You can go back with the bailiff. Zarek, trustee.
That's one that we reset. He's not, well, he may be here. We don't need to bring him out, George. his family was supposed to provide me a video or some evidence, and they've done that. We've had the investigator upstairs listen to it. Apparently, it was already sent to, I guess, BPD, or one of the agencies, so we need to get that for the prosecutor to hear. It's Mr. Coleman's case, Judge.
Okay.
So, and
Just a normal reset?
yeah, and I'm gonna probably
we'll
need to
reset.
file a request for bond reduction, because based on what I've heard, it indicates that he may have actually used it.
Okay, yeah,
I'll do
if
that.
we'll do a normal reset. If you file a motion for a bond reduction, we'll move it up.
Yes, sir.
All right, so trustee will get reset.
Good morning. Good to see you.
You too.
Sorry
That's all right.
about the kids.
Good morning, sir. You're Timoteo Castaneda?
Yes, Mom.
And in 25 DCCR 0360, Mr. Castaneda is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, if we could come back, we're very close. We're trying to get a probation offer, and once we get that, this will be resolved. We're just not quite there just yet. I think we've only been here once.
Well, it looks like you were hired in May, so this will be the last reset on this
Okay,
case. So, Mr. Castaneda, make sure you stay in touch with Mr. Crenshaw so that any information he gets from Mr. Hoffpower, you guys can go over and we'll get an announcement at that next court date. All right, thank you.
Good to see you.
Catherine Jordan, Mr. Crenshaw.
Yes, Your Honor.
Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I assume the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened, and hopefully not engaged in the type of conduct that caused us to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So, yeah, obviously, if the court repeats 5, the court's inclined, because of her criminal history, to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address the court as well. Is that right? What do you have to say for yourself?
I apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full wage.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of page and a half of misdemeanor thefts on this pre-sentence report, where you were put in the parish jail, and then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years was, it looks like, you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, you know, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry, 25 DCCR 0979
the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just said on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated. All
Okay.
right. And we have to have that discovery certification today because the case is going to get to close
And not
down.
again, you never gave it to me.
Well, I mean, when she first pled.
So do I?
You didn't give
You
it.
to give me a
Did I get the credit for me being here on this?
Yes, all the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you.
Is it 8 years, Judge?
8.
This defendant's
Yes.
in the hospital.
Who?
This Robert.
Oh, the defendant. yes.
Defendant is in the hospital.
They're the same.
Okay, whose is that? So we'll obviously reset, Desron Roberts.
He's in the hospital.